Before we dive into our short-term rental webinar, let me tell you briefly about CCI for those who may not be familiar. CCI is a nonprofit organization made up of volunteers from all corners of the condominium community across Canada. We are 17 chapters spread throughout the country, including a chapter here in Manitoba. Each chapter has a volunteer board of directors representing a mix of folks from the community and the condominium industry. Our Manitoba chapter blends industry professionals, condominium corporation directors, and condominium owners. We're here to share the knowledge, connect, and support with each other within the world of condos. CCI celebrated our 40th anniversary last year, and we're looking forward to decades of further involvement in the condominium community. All participants in today's webinar that are not currently CCI members, I'd like to remind you that memberships are now half price for the remainder of our membership period, which ends on June 30th, 2024. If you're interested in a trial membership as an individual member, the cost now is only $25. Membership provides you with access to educational events in person or online, the quarterly CCI newsletter, free admission to all CCI activities, as well as the benefits of knowing that your voice through your membership will be heard. Today's webinar sponsors are Hub Insurance, BFL Canada, Efficiency Manitoba, and Schinkel Properties. CCI Manitoba acknowledges the important role our sponsors play in fulfilling our mission to provide education, information dissemination, workshops, and technical assistance to the Manitoba condominium community. This webinar will be a maximum of 2 hours in length. If we finish the presentations and Q&A before that time limit, we will conclude early. All questions can be submitted via the chat button at the bottom of your screen. We'll do our best to get to all the questions submitted and answer them within our time constraints. We're fortunate today because our panelists are experts in condominium law and municipal bylaw development, education, and enforcement. The panelists for today's webinar on short-term rentals are Douglas Forbes. Doug is a partner at TDS Law and specializes in corporate and commercial law, real estate law, condominium law, and condominium law. He advises a diverse clientele, including businesses, corporations, nonprofits, real estate developers, and condominium corporations on local, provincial, national, and international matters. Doug is a member of the Canadian Bar Association, Manitoba Bar Association, and the Law Society of Manitoba. He is an expert presenter on condominiums and business transactions, has been a professional member of the Canadian Condominium Institute for over 30 years, and has served as the president of CCI National and CCI Manitoba, and is currently a member of the board of directors of CCI Manitoba. Winston Yee is is from Licensing and Bylaw Enforcement at the Community Services Department of the City of Winnipeg. And with Winston is Terry Cormier, the Licensing and Bylaw Enforcement of the Community Services Department, also of the City of Winnipeg. CCI Manitoba extends our sincere appreciation for the time and efforts provided by our presenters today. Doug, Winston, and Terry's contributions of time and expertise are invaluable to the continued success of CCI. CCI's efforts to bring you these educational opportunities. At this time, I'd like to present you our first panelist, Doug Forbes, followed by Winston Yee and Terry Cormier. Good day, Doug.
Hey, Dwayne, thanks. I'm going to try to switch my slides now, and apologies to everybody. I'm know more about condominiums than I do about. Oh, there we go. Is that working?
Yep, looks good.
Okay. There we go. Okay. So thanks, Dwayne. Yeah. So welcome, everybody. Thanks for coming out and participating in this. Short-term rentals have been a hot topic in the condominium world for well over a decade. I'm bad at remembering when it first started, remembering dates and judging how long things have been around, but at least over 10 years. So I'm going to go through most of my presentation will not have anything to do with the new city bylaws and the enforcement regime, because our next two speakers will deal with that. I will talk a little bit about how they interplay, but I'm going to leave that with them. But I'm going to give a presentation on short-term rentals, and I'm going to do it from the perspective. I have a bias in my towards the condominium corporations that want to restrict short-term rentals in their buildings and in their complexes. And that's not because it's right or wrong. It's just because that is most of the people that contact me in my as my capacity as a lawyer are wanting to restrict them. So it's sort of where I spend most of my time thinking about the issue. CCI itself, and me included, really don't have an opinion on whether or not you should or shouldn't allow short-term rentals within your condominium. We do, however, have a strong opinion, and it's the position of CCI that condominium corporations should be able to decide and whether or not they allow short-term rentals within their complexes, but leave it to the democracy that's within each corporation. So I'm going to present on the history of the problem. The problem being that short-term rentals have not been able to be regulated. How the problem has evolved, or the solution has evolved. I'll get into what the actual solution is, and then deal a little bit with how we're going to deal with the how condominiums will be dealing with the city bylaws and how they interplay. And then I've got the typical lawyer disclaimer at the bottom of this, that the information provided is for general information purposes only. It's not legal advice. Bottom line is condominium corporations, before they do anything, should consult with their property managers, consult with their lawyers, and because this is just general, and your situation may be different or has some nuances to it. So with that in mind, I just want to remind everybody that really we're dealing with 4 levels of government when you have a condominium. The federal government, which doesn't have a lot to do with condominiums. The provincial government, which does have a lot to do with condominiums, of course, because the Condominium Act and the residential tenancy.
Can I just jump in for a second, Doug?
Sure.
Your PowerPoint is minimized, and we're seeing as much of your desktop as we are the PowerPoint.
Okay. Does that help? No?
I think it looks better.
Okay. I've got it full on my desktop, so can't change that. But,
okay.
Okay, but anyway, I'll go on with that. Apologies for the technological snafu. In any event, I was saying we've got 4 levels of government. Provincial government, of course, has the act. The municipal government, which of course affects properties within whatever municipality you happen to be in, and then the 4th level of government is the government of the condominium itself. And with that, we've got the Condominium Act, we've got the declaration, the bylaws, and the rules of condominiums. So the main, or the cause of the problem that I think is the cause of the problem that started the whole issue is in 2015, the province passed a new legislation, and within it is a section. There was, in the old act, had a section like this as well, but it says that a condominium corporation must not prohibit, and I underlined that for a reason, the rental of a unit by the unit owner. And then the problem is trying to interpret the meaning of prohibition. There are the Manitoba Land Titles Office and Residential Tenancies Branch took the position that the word prohibit means that you can't do anything to restrict the rentals of any kind, including short-term rentals within a condominium. Many of us argued that a condominium corporation that wanted to put a minimum term, we weren't prohibiting it. We were just putting some parameters around it, or some guidelines around the issue. So many corporations years ago, we were trying to file documents within land titles that said, a minimum term of say 60 days or 30 days or 90 days. And the residential tenancies branch actually took the position that was prohibiting and therefore should not be allowed. And land titles took their cue from that and started restricting, starting not allowing those amendments to declarations or bylaws to allow that sort of restriction. So it was a problem, and it looked like we were stymied. But then a number of other provinces, Ontario was a big one, BC somewhat, started to develop case law, and the courts started to decide that there was another way to get at the issue, and that is most condominiums, including Manitoba ones that are residential, have a clause in there that says that the residential units must be used for single-family residential purposes only. So the courts in the other provinces started to interpret that and interpret the use of a unit for short-term rentals, particularly ones that are very short-term and aren't being used as primary residences, as being used for a commercial purpose and not a single-family residential purpose. So because if you're running say an Airbnb and people are coming in and out on a fairly short-term basis, they viewed that as akin to running a hotel or something like that. So they viewed that as being in breach of that section within the condominiums declarations and all that. Now I have to point out that there was no Manitoba court decision on that point. We tend to not have a lot of litigation regarding condominiums in Manitoba compared to other provinces, and this was one of the cases where we never had a decision. So with that, corporations were able to go, if somebody was running a short-term rental operation, and seek an order from the court requiring the unit owner to stop doing so. The problem, though, is that, as everybody knows, when you go to court, it's expensive, and it takes a long time. So it's not a great remedy to have. And we started looking at trying to find some way that would be able to get us there, without having to go to court. So some corporations started passing rules in order to deal with it, and focusing on and trying to interplay with the declaration restriction on use being limited to single-family residential.
Sorry to jump in again, Doug, but your slides are not moving. They seem to be frozen on the first one.
So, okay, well,
sorry about that.
Maybe is it moving now?
Yes, it looks better now.
Okay. So I'm down to here. Okay, I see. I've got it's not picking up the screen where it's just the current slide, but this should work, I think, hopefully. In any event, the problem with the good thing about rules is that if you pass a rule, if a condominium corporation passes a rule, then the rules aren't filed in land titles, so you can pass a rule and have it become effective, but you don't get judged, and land titles doesn't have a say of whether or not it's going to be passed. A bylaw amendment or a declaration amendment, in order to be effective, has to be filed in land titles. Rules do not. I mean, you could get into an argument if you're going to challenge a rule, whether it's whether it's legal or not, then you'd have to do so in court. And of course, many of us are of the view that these rules were within the jurisdiction of the corporation to do and complied with the Condominium Act to do. So anyway, the corporation started filing or passing rules that put parameters around terms and that would then restrict short-term rentals from being used within the various buildings. The good thing about a rule is that if you breach a rule or a bylaw, but not a declaration, then if your corporation allows for fines and has the proper language within the bylaws for fining, then you can start to fine those who breach that, and then you don't have to go to court, and you don't have to spend the time and money to get that through. Now, fines under the Condo Act are limited. Some might argue that they are too small and they can't be levied enough, but it was better than nothing, and people started proceeding in that way. So meanwhile, while this was going on, and that workaround was being had, condominium lawyers, myself included, and I have up here worked with LTO to try to resolve the problem. And work with also means working with, but also fighting with and trying to persuade. And in all fairness, I think the folks at Land Titles got the problem. They just didn't think that they had the capacity to allow those to be passed. They were sympathetic with the plight, but they didn't think that they could do it. Though we started to look at the Residential Tenancies Act, and by we, I mean condominium lawyers and CCI and the folks in Land Titles, and started thinking of another way to accomplish the same end. And at the same time, CCI, and this was about a year ago, not quite, met with the minister responsible for the Condominium Act and a number of high-level provincial bureaucrats on a number of issues, but one of them was this. And they resolved to look at it as well. I never heard that they communicated with Land Titles or not, but shortly after, Land Titles started becoming a lot more cooperative. The workaround what we were getting at is the Residential Tenancies Act, which is the RTB's jurisdiction, doesn't apply to accommodation of a transient basis. The transient's not a nice word, but that's how they put it in the act. And that would include a hotel, a motel, a hostel, that sort of thing. So we started to look at using language like that, and we came up with a solution. So as a result of that, Land Titles will now accept language in declarations and bylaws that restrict short-term rentals if you can draft it in such a way that it clearly avoids the jurisdiction of the Residential Tenancies Act. I'm pleased to say that Land Titles is now accepting that, and it's a recent development. So if you're a condominium corporation and you're interested in a restriction beyond the one that we talked about earlier in the declaration, they will take some language. And this is actual language that I have contained within an amendment to a bylaw that they've accepted. And I've done it for a few corporations. The language varied a little bit for each of them because of their particular circumstances, but I'll just read it out. It says the units may only be used as single-family residences, again, picking up on what's in the declaration, to be occupied and used as private single-family dwelling. The use of a unit to provide living accommodation occupied on a transient basis, similar to a hotel, motel, inn, tourist home, or hostel. And that's picking up right in the language out of the Residential Tenancies Act. Including where such use is facilitated by such applications and agencies as Airbnb, VRBO, Flipkey, Vacasa, is a commercial use and is strictly prohibited. That then we've sort of come around full circle, and over the course of a good long period of time, we are now able to, corporations that want to make this sort of amendment to their declaration, bylaws, or rules can do so and put something like that in. So, and again, another lawyer language at the bottom, but make sure that this fits with your corporation. Don't just use this particular language and there we go. Don't you just use this particular language. Oh, it's not moving the screen at all. Oh, well. So just anyway, I think we'll probably distribute the slides. If somebody wants the slides, they can send me an email. I'll certainly send them out to you. But but don't just use the language that I just said without talking to your legal advisor and your property manager, because you got to make sure that it fits with your documents and fits with your community. So there we go. That worked then. There's the language. No, anyway, sorry. I hate technology. Anyway, so then the question is, where do you put that language? Do you put it in the declaration? Declaration, because it takes a declaration is the most difficult condominium document to amend. So in order to get it in, it's also the most difficult to take it out. So that's worthy of consideration. The problem with putting it into the declaration is that, pursuant to the Condominium Act, you cannot levy a fine if there's a breach of the declaration. Your recourse is to the courts. You could put it in the bylaws. The bylaws, with the bylaws and rules, you can levy a fine. Bylaws are registered in land titles, and they are easier to pass and to change than a declaration, but more difficult than rules are. And it's also, I don't, this is not true, but some people think that because it's registered in land titles, it carries more weight than if it's a simple rule. Both rules and bylaws would be enforceable if you went to court with them. Rules, though, are easier to pass, and you can get, and they're easier to change. It's easier to delete. So there's some strategies of which document you want to put that language in, and it will depend on your corporation situation. So so that's basically been the workaround. Other issues before we get into the city bylaw is I often get asked, are leasing levies applicable to short-term rentals? Leasing levies, for those who don't know, are levies that a corporation, if it's allowed in their declaration and bylaws, allow a corporation to levy a leasing levy on unit owner that rents his or her unit out. So that would be, and it's up to a maximum of $1,500. And it's similar to what, like a damage deposit. The corporation holds it and has access to it if the tenant causes some damage and the unit owner and the tenant don't make good on it. So they have access to that. So I believe that leasing levies are applicable, and a corporation is entitled to receive that. There are also notice provisions of leasing within the Condominium Act. If you lease out your unit, you're to provide notice to the corporation. They're not really that applicable and or practical in condominiums. Oh, there we go. Sorry, I'll just show people the. There's the solution. There's the language that I was talking about. I don't think that leasing levies are that applicable. Or sorry, leasing levies are But the notice provisions are that practical because you've got 30 days to give notice. And a short-term rental, if you're in an Airbnb situation, if they're a week or less, then you don't, the person is left by the time you are required to give notice. So dealing with the interplay with the city's bylaws, now the city, as we're going back to what I said before, the city is a different level of government than the corporation. So if you have somebody who's breached the city bylaws with respect to short-term rentals, it doesn't necessarily mean that it's a breach of the condominium documents. And if you're a condo board, you can't take any action by virtue of somebody breaching the city bylaws. You can only take action if it breaches the declaration, bylaws, or rules, or the act of your condominium. Vice versa, if you've got a breach of the declaration, the bylaws, the rules, or the act, that doesn't mean you can call up the city and ask them to enforce it. You can't. It's a different level of government, and they don't. A breach of one does not necessarily mean that you breached the others. And the remedies that the condominium corporation can have is independent of the remedies within the city bylaws. So you've got they are completely different regimes. Now, a corporation could pass a rule that required compliance with the city bylaws. I would caution you from doing that. I've not seen it done. I think it could. I think it would be enforceable. But the problem is if you do it for all city bylaws, it may impose an obligation on the corporation, condominium corporation, to enforce pursuant to their bylaws and regulations any breach with any city bylaw. So you have to know all the city bylaws, and there are a lot of city bylaws that are applicable to condominium corporations. And I don't think a volunteer board or a property manager wants to deal with that. So I would leave that alone. If you wanted to say breach of the specific city bylaw, such as a short-term rental situation, is a breach, and put that into the rules or into the bylaws, I think you could, and it's worthy of consideration. So the one thing that where the two do overlap is the application process to obtain a license in a condominium provides that the unit owner should provide a letter of approval. It's called in at least on the city website. Or a letter, or maybe it's a letter of permission. But either way, I think approval or permission might be too strong a word. If you have, this is obviously new territory, but it's one thing to say we approve. It's another thing to say that there are no provisions within the condominium documents that would prohibit somebody from operating a short-term rental within this condominium, which I think is probably the better language for both. The other situation is if you're asked for that, if your board doesn't want to give that, but you don't have a restriction within the bylaws, I don't think you can withhold it, because I mean, it's one. I don't think you have to say, we approve it, but you can say that, and you should say that is not prohibited. And I think boards that when they get that request need to deal with it on a timely basis. That doesn't mean a 2-day turnaround or anything like that. Boards only meet once a month usually. So I think it's fine to put it off to the next meeting, or you could delegate it to your property manager. Could you qualify it? Yes, I think you could. And I think maybe even properly should do it. If you say there's no prohibition, however, there is a amendment to our bylaws that's being considered by the unit owners in an upcoming meeting that would prohibit it. I think that's fair to put in. And frankly, if I'm a unit owner, particularly if I'm a unit owner interested in buying in the corporation. I think that the unit owner should know that, as well as the city. And in terms of the form of the letter, I don't know yet. We haven't done that, but it'll be interesting. These things, I think, over time will become fairly standard, but we're not at that stage yet. So with that, I am looking forward to the gentleman from the city, because we're all on a bit of a learning curve with this. April's approaching where this will all come into play. So I'm excited to hear what they have to say. But I would point out that when you're asking questions and comments, the time to talk about what should be in the city bylaws is over. It's been passed, and these gentlemen are here to talk about how it's going to be interpreted and how it's going to be enforced. If you don't like what the bylaw actually says, then the folks to bother are your city councilor and the mayor. But for now, I think the city thinks that this is done, and what we're dealing with now is what's going to come into effect. I believe it's April 1st. So with that, thank you very much. Really sorry for the technology issues. I'll try to do better next time, and looking forward to the questions. Thanks.
Okay, thanks, Doug. We thought we had the technology figured out, and unfortunately, I guess we didn't. We'll do better next time. I'd like to now introduce Terry. I believe he's starting up. Is that correct, Terry?
Yes, that's correct. Thank you, Dave.
Okay, we'll hand it over to Terry, and we're eagerly awaiting your presentation.
So now it's my turn with technology. Let me see if I could get the appropriate screen up here for the PowerPoint presentation. Did that properly pop up there for you folks?
Looks good from here.
Yes, it looks good to me.
Awesome, thank you. So thank you for the invite today. As mentioned earlier, my name is Terry Cormier, and I'm the licensing coordinator over here with the Community Services Department, Licensing Bylaw Enforcement Services. Also joining me today is Winston Yee. He's our manager over here at Licensing and Bylaw Enforcement. The plan is I'm going to go through the PowerPoint presentation. If Winston would like to add in anything, he might jump in, and he'll also be involved with me to answer any questions as we kind of go through the process of this afternoon's presentation. As was mentioned earlier by Doug, the bylaw has been passed. So there was amendments done to the community safety business licensing bylaw back in November of 2023. And those amendments to the licensing business licensing bylaw added short-term rental accommodations to the bylaw. And that's what we're here to speak to today. As Doug had mentioned, the bylaws already in place with the coming into force date come April 1st of 2024. So today I want to speak specifically about what that bylaw looks like. Just bear with me, I'm just trying to change the screen here. Is the screen changing on your side? There we go. So just to provide a little bit of a brief overview of our path down to regulating short-term rentals. As some folks may or may not be aware, the city did undertake various public and stakeholder engagements, and we conducted multiple jurisdictional scans on various regulation models used in other cities across Canada to inform the work that we did in the creation of our bylaws specific to short-term rentals. Council did give us direction that we had brought forward a report that initially outlined steps of implementing a licensing and taxation framework for amending the bylaw that, as I had mentioned earlier, will come into force April of 2024. When we were looking at putting the framework together, there were kind of four main goals and or objectives that we were looking at. Those goals and objectives, based on the feedback from council and some of the jurisdictional scans and stakeholder engagements, we landed on the main goals being community safety, consumer safety, neighborhood livability, and the ability to foster equity in the accommodation industry. So a little bit more background. From the start of discussing the bylaw to actually implementing it come April was roughly a 2-year process. So in June 2022, council directed the public service to conduct public engagements and to report back on framework specific to regulating short-term rental accommodations in Winnipeg. In February 2023, council approved the framework of a 3-part regulatory program that includes the 3 departments, that being community services specific to the community business licensing bylaw, assessment and taxation that talks about the 5% tax, accommodation tax on such rentals, and the zoning bylaw through planning and property development. The proposed zoning bylaw amendments which introduced in Winnipeg zoning bylaws as yet land use in certain districts was part of a different report, but was part of the 3-part regulatory program that was presented. Licensing and enforcement program. So as part of the approval of this new program and or bylaw, the approved program resulted in 2 new classes of business licensing, one being short-term rental accommodation operators, and the second one being short-term rental accommodation platforms. Within that framework, there was some limits that were identified for licenses per operator. So the breakdown of the 4 licenses is 1 for a primary residence, which is only available to individuals, not corporations. And then in addition to that, 3 non-primary residents with a couple of stipulations that individuals or corporation must be Winnipeg residents, and that properties owned are required to be on or before February 23rd, 2023. So those were a couple additional stipulations that council put on the framework for short-term rental accommodations. So at a very high level, the licensing program will require that all short-term rental accommodations be licensed annually. They'll be also required that all short-term rental platforms be licensed annually. Will require that short-term rental accommodations use a licensed short-term rental accommodations platform for all bookings of short-term rental accommodations. So once again, that's the connection of the accommodations to the platforms. And there are certain things that are imposed requirements on owners specific to protect the safety of both the community and or renters. We're also looking for information on past noise nuisances and or a history of noise nuisances within each application, and that will potentially allow us to impose some specific conditions on licensee should need be, if there is a requirement, either at the time of application and or after application if issues do arise. We do require that all short rental accommodations operators get approval from the Winnipeg Police Service Records Review Board as part of the application process. In addition, I kind of mentioned this earlier, but it goes into a little bit more detail for short-term rental accommodations property. owned on or before February 2023. We will allow a maximum of 4 short-term rentals for an individual owner when being the individual's primary residence, with a maximum of 3 non-primary short-term rental accommodations owned by an individual or corporation, provided that the properties are only owned by Winnipeg residents. The individual or corporation own the properties on or before February 23rd, 2023, and that the short-term rentals are permitted under the appropriate zoning bylaw. For short-term operators owned after February 23rd, 2023, all short-term rental accommodation operators would be specific to primary residents only, with a limit of 150 nights per year without the owner being present in the residence. So if that primary resident decides to go on vacation for 4 months, he's allowed to rent out the entire unit for 150 nights per year. And there would be no limits on the nights rented if the owner is on premise. So if the owner is there, they'd be able to rent it out 365 days a year. Some ongoing requirements that are part of the bylaw. We do have limits to 150 nights per year that a primary resident could be booked without the owner being present in the residence. That's kind of what I was mentioning earlier. We impose requirements on owner to protect safety of both the community and renters. That kind of speaks to fire alarm requirements, extinguishers, carbon monoxide detectors, and various rules within the short-term rental accommodation bylaw. There is also information that will be required to be shared on sex trafficking that was put together in partnership with the Winnipeg Police Service and the Joy Smith Foundation. Another requirement is the post of licensing number with a telephone number that is monitored 24 hours a day. I do know that there was one question that I had reviewed. What does that mean? Would it be posted on the unit or at the front of the apartment and or condo? The goal and the intent would be it would be posted on the unit. So on the unit door or in front of the unit door. And that renters do not cause a noise nuisance or engage in behaviors which will create an undue nuisance to other residents. They're also required to maintain appropriate records and provide those records to the City of Winnipeg upon request. They're also required to post their license number on any online or physical advertisements. Limit the number of adults to 2 per bedroom, and limit the short-term rental period to a maximum of 20 consecutive nights per bookings. So let's talk a little bit about the application process. So we are looking at opening up the application process in the coming weeks. Our goal is to have an online format for applications, as I mentioned, to start at the end of January 2023. Part of that application process talks about zoning approval. So once the application comes in, we send the information to zoning, and they would give the appropriate approvals based on the location of the short-term rental accommodation. Obviously, they would need to have a completed application. They'll be required to do a criminal records review application as part of the application process. To disclose any previous noise complaints related to the short-term rental accommodation. Letter of approval from condo board and or landlords if applicable. Once again, I know this kind of came up in Doug's presentation that for the application to even move forward, we would require that approval and or letter from the condo board or landlord. As Doug said, maybe not approving, but giving permission for that short-term accommodation to occur within your condo and or apartment building. And in turn, if it's a primary residence, we will require evidence that the property is your primary residence and some floor plans and safety plan information as part of the application process. Licensing application process, I won't get into it too deep in regards to what the platforms are required. But the platforms will be required to have a completed application. We are asking for a listing of all short-term rental accommodation properties listed within their platforms. We're asking for the companies to provide their operating procedures on how to address short-term rental complaints within their platforms, along with provide an address for service for us to easily communicate with them. On the accommodation tax side of it, so part of the bylaw requires that operators collect a 5% accommodation tax on all short-term rental bookings that will ultimately be paid to the city of Winnipeg. Licensed operators will remit the tax to the city, so it might be collected on the platforms, but it will be the operator's responsibility to submit such fees to the city of Winnipeg. Taxes will be charged on a room cost plus cleaning and maintenance fee charged by the platform. And funds directed, that 5% fund that's collected will be directed to the destination marketing reserve. However, will also cover any expenses and licensing that is not covered as part of the licensing revenue process of the licensing program. Zoning and land use, they've identified that zoning bylaw amendments allow short-term rentals in most zoning districts that permit residential uses, except for residential mobile homes and rural residential zoning districts. Within the changes, there's not a requirement for a zoning review or development application within that process of application. So enforcement, we're going to take a proactive and complaints based enforcement process. We're in the process of hiring staff now to with the goal of definitely working evenings and weekends. And we're definitely going to be looking at trends and the complaints and or non-compliance issues in regards to identifying specifically when that enforcement team will be working. Police response to complaints can be referred to us for regulatory actions. And failure to comply with short-term rental accommodation regulations can result in could range from administrative penalties to warnings to conditions imposed on their license, to flat out cancellation of their licenses, and fines will be under the MBEA or the Municipal Bylaw Enforcement Act, and or initiating POA, which is a prosecution in provincial courts. So we have various methods of enforcement. I do know one of the questions, and maybe we'll wait till the questions come up, but the number one question is, how will complaints be received? For the most part, complaints will be received through 311. However, when situations, if there's noise complaints during the middle of the night, 2 or 3 in the morning as an example, those complaints would still go to the Winnipeg Police Service to deal with any immediate issues. And then in turn, that would be referred to us to deal with any longer term issues that might come up with that operator. I think that concludes our brief summary of licensing and what the new bylaw looks like. I thank you for the time, and I look forward to any questions that we would be able to answer as the next step of the presentation.
Okay, thank you, Terry. Does Winston have anything that he would like to add or build upon?
Yeah, thank you, Doug. Nothing further. We'll just answer the questions. I see that there's a number of questions that have come up in the chat.
Okay. I will do my best to kind of go through the questions. I'll pose them and either directly to one of the panelists, or if multiple panelists want to answer the same question from a different perspective, then that's perfectly fine as well. I'm just going through them now. One of the questions that's been asked multiple times is if a condo corporation already has within their rules or bylaws prohibitions in regards to short-term rentals or any rentals that are less than, say, 30 days, say a 3 or 4 day rental that's typical with a short-term rental. If they already have that within their bylaws or rules, does that mean that someone who owns a condominium within that corporation will not receive a license from the city?
So to answer that question, if we don't receive the letter that approves or supports the operation of a short-term rental within that condominium board, the application would be stopped at that time and would not proceed.
Okay, and these letters that prospective STR operators would have, I'm assuming they would have to seek them from the board of directors within that condo corporation, and then they would have to submit them along with their application for a license?
Yes, that's correct.
Okay. Also, there was a question in regards to the 150 night limit. The question states, does the 150 night limit for primary residences not apply to units owned before February 23rd, 2023?
Could you repeat the question again? Sorry about that.
Does the 150 night limit for primary residences apply to units that are owned before February 23rd, 2023?
Yes. Yeah, it would.
It would apply.
The 150 night, yeah, if the property was owned prior to the February 2023 day and they're applying for a primary residence, that 150 days would apply, if I understand the question correctly.
Okay, so to clarify that, if you want to operate a short-term rental within the city of Winnipeg, moving forward, you're going to require a license regardless of when you owned it or how long you've owned it.
Correct.
Just for a point of clarification, Doug, I think with the question, it can be interpreted a couple of different ways. So we don't regulate anything that happens prior to February 23rd, 2023. That trigger date is for ownership, right? So we've grandfathered non-primary residents, right, to get a license if they're owned as of that date. And then going forward, they can be licensed. So I think when the question is asked about something about the 150 nights prior to that date, we would not enforce retroactively anything, just for clarity, if that's the intent of the question.
Okay, I think, yeah, that clarifies it. And is there, what's the easiest way for someone that requires further information in regards to licensing? Who would they contact within the city?
Yeah, thank you for that question. So currently our website is fully updated, so it's winnipeg.ca. If you go on to business licensing and then click on short-term rental accommodations, we have all our information is posted up within that website. If there's any additional questions, there's a link to our CMS licensing email address, which is cmslicensing@winnipeg.ca, that individuals could contact us through email if they need or have any clarifying questions related to the specific bylaw and or licensing requirements.
Okay.
For those, Dwayne, for those who memories short like mine, I was able to find the website by just Googling City of Winnipeg and short-term rentals and got it no problem. And we all know how good I am with technology, so anybody should be able to do it.
Okay, good. That's good clarification. Another question asked is in regards to bylaws or fire safety codes within the city of Winnipeg. Do they apply to short-term rentals? Will your office, Terry, be enforcing those or looking for compliance of those codes?
Specifically, we'll be looking for what's in the community safety business licensing bylaw. You know, and we'll be working towards what information is required within that bylaw that states stuff such as smoke alarms, carbon monoxide detectors, fire extinguisher issues, stuff like that. And there are other processes already built into our inspection processes that would identify if there are issues in regards to egress issues or anything like that.
Okay. Just going through some of them here. Are there any, one of the questions is, are there any specific zones in regards to the city that are exempted from short-term rentals, or any areas of the city of Winnipeg that would be exempted?
Not based on the zoning bylaw that was presented. There was only those couple things that I had mentioned within my PowerPoint presentation, mobile home parks, and I think there was one other one that I can't remember at this time, but it was in the PowerPoint presentation.
Okay. And just for clarification, one of the questions asked, your office will only be enforcing these bylaws in regards to short-term rentals within the city of Winnipeg, so that if you live in East St. Paul or Headingley, these rules don't apply.
That is correct.
Okay. And so those jurisdictions would then have to, if they choose to, develop their own enforcement regime outside of the city.
Yes, that's correct.
Okay. And this question is probably more in relation to your presentation, Doug. If a condo corporation does not have anything in their bylaws or rules that address or relate directly to short-term rentals, but yet the corporation is now looking that they've got to address that issue, in your opinion, how do they go about that?
Well, the first step would be, I would urge you to contact your property manager or your the lawyer for the corporation and talk about putting in a provision that deals directly with short-term rentals, and consider whether it should go in your bylaws, your rules, or your declaration, and what's right for your corporation and what you have the political support for. It's easier to pass a rule than it is to pass a bylaw or a declaration amendment. So start there, and I wouldn't rely on the declaration provision for, or solely rely on, I shouldn't say that because you can't rely on it, but solely rely on the provision about, you know, for single family residential purposes only. I would strongly suggest that corporations consider adding in language such as the sample language that I spoke about.
Okay. This question would be directed to Terry or Winston. Can you offer any explanation or any insight into how investigators would have any meaningful enforcement of the 150 night limit going forward within the bylaw regime?
Yeah, so we're currently working on our enforcement processes, and we've I wouldn't say hired, but we've looked at specific software that takes a look at specific platforms and scrapes information from them in regards to potentially booking, what's the word I'm looking for, that takes a look at the booking processes within each platform. That's one way that we're kind of looking at it. But being in the early stages, we're still working on our enforcement processes specific to the 150 night rule as one example.
If I can also add, and first of all, my apologies to your audience because I had technical issues, so I'm on my cell phone signing into this. So as Terry's saying, we're fleshing out our processes, but we have a very rigorous, I would say, mechanism to determine all the ads for bookings that are out there. And there is a requirement in our bylaw for all operators to maintain their documentation for at least 3 years. So that gives us audit capabilities on many of the licensees that will be operators that will be out there. And we also work on complaint based. So, you know, if some of your audience is there, or whether they're owners, it's good to have good relations with your neighbors. But if we get complaints from any of the neighbors, or if it's within a condominium, any of the other unit owners, that there's a high frequency of people coming in and out, then we could identify that, look at it from an analytic perspective, and then be able to determine if they are in violation or not.
Okay, thank you. One of the questions questioners asked, because they've expressed some concern because their condo corporation and through their property managers have been dealing with some of the platforms, such as Airbnb or Nest Host or VRBO, in regards to compliance issues. And they've received what, in their words, is less than stellar response from the platforms. Do the enforcement departments within the city of Winnipeg have a plan of how to deal with these very large corporations, such as Airbnb? That's a very large corporation. How are you going to deal with them if compliance seems to be an issue?
Yeah, that's a good question. What I could say is we've engaged with the larger platforms for the last 2.5 years or so since this process has started. As you saw within the presentation, it is a requirement of a platform to be licensed through the city of Winnipeg, which also spells out requirements that they need to provide to us. So we're going to continue to work on that relationship with these specific platforms and keep them accountable to our bylaw in regards to what their requirements are as a licensee, and we'll continue to work with them and address any issues as they come up.
Okay. Also, within the bylaw, there is a mention, one of the questioners asked in regards to information from the police, and that there has to be some kind of, I would assume, a background check. Can you offer any insight as to what information the police might provide that could be considered adverse, that would result in a license not being issued to an applicant?
It would be, once again, very specific at a high level type of information that the police would identify to us if there's any issues. So not speaking specifics of what exactly it would be, but the police would take a look at a very high level of what's going on at that property and our operation to provide a red flag to us should there be any issue. Winston,
Okay.
I don't know if there's anything else you'd like to add on to this one.
Yeah, I mean, it's a criminal record. So if there's a record of conviction specifically, and we'll be working in partnership with the police service, but what could prevent someone is obviously, I would suggest, being charged and convicted on human trafficking related issues that might be tied into some of these premises that could be leveraged for that. So that could certainly be a significant consideration. The other ones, again, we'd have to weigh with consultation with the police, and Terry's group works hand in hand with the police service, not just from the licensing perspective, but from an operational perspective as well. I think there was a question asked earlier, Terry to present it. If there are issues related to STRA and how they are operating, they continue to go through kind of our 311 system. The police are essentially the first responders. We become a bit of a additional tool that they can utilize if they have ongoing issues with the STRA and its operation.
Okay, thanks. Another question answered or asked is if there are multiple partners that own, say, a condominium, and one of those partners lives outside of the city of Winnipeg, is that going to have an adverse reaction or an adverse result in regards to an application for a permit? Or do all the condo owners have to live within the city of Winnipeg?
So just to clarify that question, we're talking about a specific unit within the condo?
Yes.
Yes, they would all need to have Winnipeg addresses to be qualified for a license, to qualify for a license.
Okay.
Both directors and or individuals, board members would need to have Winnipeg addresses.
Okay. So to kind of just expand on that a bit, if someone owns a unit within a condo corporation within the city of Winnipeg, and it is not their primary residence because let's say they live in Toronto or Vancouver, but yet they own this property here in Winnipeg in a condo corporation, does that mean they can or cannot get a permit?
They cannot get a license.
Yeah, if I could just add to Terry's, it's specifically in our bylaw under 61.8 sub 1, and I'll just read it for your audience because if there's any contention with it. So it's a condition on non-primary residences STRA licenses. In order to qualify to obtain a non-primary resident STRA license under this division, an applicant must provide evidence sufficient for the designated employee to reasonably conclude that the applicant is one of the following: an individual, so A, an individual whose primary residence is within the boundaries of the city of Winnipeg; B, a partnership whose members all have primary residence within the boundaries of the city of Winnipeg. So that specifically goes to the question that you had asked. Or C, a corporation whose shareholders all have primary residences within the boundaries of the city of Winnipeg. So this was a decision made by our council to specifically want full ownership of any STRAs, specifically against non-primary STRAs, to be Winnipeg residents.
Okay. That's useful. Some of the other further questions, there are far more questions here than we'll be able to get to today. But I'm trying to pick out the most relevant ones that would probably be of the greatest interest. And here's one that I've seen it listed a couple of different times. If if someone owns a residence that they want to list on a platform, and they want to break the residence up into separate units, such as, let's say it's a condominium corporation or a condo that has 3 bedrooms in it, and they list these bedrooms individually as opposed to the one entire condominium unit, can they do that under the same license, or would they have to have multiple licenses that are attached to each, say, bedroom?
It would be one license for each bedroom.
Okay, and I guess that would apply to, say, a house that's in a suburb that somebody, whether it's their primary residence or not, they've got multiple bedrooms, they want to list it separately, they're going to require multiple licenses?
No, they would require one license for that property.
Okay, just for that property.
Correct.
Okay.
And that's just to elaborate on that one specific, it's part of our licensing fees. Like our fee structure is that if it's a primary residence is $260. A non-primary with 1 bedroom is $260. If it's 2 bedroom, so you have the ability of renting out 2 bedrooms to 2 different clients, it's $520. So again, it's one license, but the fee is $520. If it's a 3-bedroom home, they could rent all 3 bedrooms, right, under the one category license, but that license is $780 and so forth.
Okay. Also in regards to the, I guess, lack of a better term, a deco or some kind of notice that's on the door of, say, in a condominium corporation, where you've got a hallway with multiple doors that lead off to multiple condominiums. These notices that are on the door that list the license number and a phone number or contact number, can you give us some idea of what they're going to look like, the information that is going to be required?
The information that is required is exactly what you said, license number and or operators contact information. The goal is that the operator needs to be available 24/7 for any calls that they receive. The goal of that piece within the bylaw is specific to neighborhood nuisances, right? So once again, if there's an issue going on at that short-term rental unit, there is a requirement that if someone is calling and complaining, that they should have access to that operator to be able to express concerns and or to address the issue that's going on. And if, for instance, if someone does call that number and it's not addressed, that would definitely be something we'd be interested, that a complaint could be put in to say that we're calling the operator's number on the door of the unit and no one's responding, and we would investigate it based on that complaint.
Okay, and these stickers or decals, they have to be placed on the door in a particular place on the door, or just anywhere on the door?
I believe the bylaw says in a prominent location visible to the general public, so it needs to be visible. We're not very specific in regards to what exactly it needs to look like. We're just saying where it needs to be and the information that needs to be provided.
Okay, and these stickers are not going to be issued by the city. They're simply going to be a sticker that the condominium owner is going to have to purchase and then put the required information on it and then put it on their door.
That is correct, yes.
Okay, and if they fail to put that sticker on the door, that placard, is that an offense under the bylaw?
Yes, it is. Yeah. I'm not exactly sure what the fee is off the top of my head, but it's definitely an MBA fine defined within that bylaw that we would issue a ticket if that's not provided.
Okay. If a condominium owner or someone acting on behalf of an owner decides to forego the licensing and still continue to advertise on a platform of their choice for a short-term rental, how does someone, if somebody in the condo corporation, being on the board of directors or a property manager or someone who lives in the nearby unit, who do they call?
They would call 311 directly to put in a complaint specific to that short-term rental operator. The reason why we say 311 versus the CMS licensing that I gave you, CMS licensing is general information. 311 is a very documented, recorded system that takes in the complaints and gives it to us appropriately. And there's specific service level agreement pieces in place that need to be addressed in regards to addressing that complaint.
Okay. Another question that's been submitted is, could a condo corporation be proactive and provide to your office through the form of, say, a letter from their property manager or their lawyer stating that it's their position based upon their past bylaws and rules that they do not consent to any licenses for short-term rentals out of their corporation? Could they do that proactively, or is this to your office?
No, I think we want to encourage communication with corporations. So if there's something that they want to share with us, such as what you mentioned, we would definitely be open to having that communication and discussion.
Okay, so if a board of directors decides that they want to send a letter to your office saying, under no circumstances do we consent to the issuance of a license for a short-term rental within our corporation located at this place in the city of Winnipeg, you'll take that letter and hold it on file?
Yeah, and once again, it's back to the whole point that we made earlier. Without that initial letter at application, we're not proceeding with applications. So if the condo board stance or their bylaws state that short-term rentals aren't allowed, there would never be a letter in the first place to issue to process the initial application of a short-term operator within a condo.
Okay.
But yes, we're open. We're sorry, Winston, you go ahead.
I was just gonna say, and as Terry's indicated, like we encourage, communication. There's a couple considerations. Number one, if in a scenario that the corporation is being proactive, we don't property manage, right? We have a licensing process in place. So yes, we can take that information, but it wouldn't really be attached to any file because there's no licensing file to attach it to. If we do get a licensing application and it doesn't come with the approval from the board of directors of that condo corp, then we would not issue a license. In this circumstance that it has been issued and now the corporation has kind of changed their position, we would look at that upon likely renewal of that license. So when we issue a license, and if the condo corporation through the duration of that license says, hey, we no longer want to approve these, that's when we'll look at upon renewal. So upon renewal, we will have that documentation in place, and we would then go back to the licensee to say, well, on your renewal, we have a letter indicating that they no longer support or approve it. You have to go back to get us a letter of approval, or we cannot renew the license.
Okay, thank you. Also, should a license be granted to someone? This is one of the questions. If a license is granted to someone who owns a condo and then uses it as a short-term rental and then sells that condo, will the permits be grandfathered, or can they be passed to the new owner of the condo corporation, or does a new owner have to apply all over again?
The new owner would need to apply all over again. But there's also the clause for non-primary residences that you need to own the property prior to February 23rd, 2023. So if it's a new owner and they're planning on a short-term rental as a non-primary residence, they wouldn't be allowed to. They'd only be able to apply for a primary resident short-term rental accommodation license.
Okay. Can you offer one of the questions asked? It's been asked several times. If you can provide some kind of an example about when complainants or people that have a concern might call your office versus the city police.
So any stipulation within the bylaw, so whether it be, we had mentioned earlier, the signage on the door, anything associated with the framework of the licensing would come to us. Where it would come to police is really the after hours, I don't want to call them nuisance calls, but issues that require police to be involved is when it would go to police. If it's, sorry, go ahead, Winston.
Yeah, if I just want to add, that's why Terry had encouraged everyone here earlier to contact 311, because that's the main point of contact for the city, and they know how to triage these calls and direct them to police where appropriate and to us when appropriate. And so if there is, for example, that someone is not posting their license number and contact information, or that they have not responded to phone calls or something like that, 311 would automatically direct that to us. And we have an automated system, which that just comes directly into our operations and then gets distributed to either our inspectors or our officers to then take up follow-up action. If calls are directed to police, again, public calls in and they determine, yes, this is now triaged to go to WPS. WPS would take action, and if they feel that there needs to be follow-up action with our operations, then they usually contact Terry's office directly.
Okay, thank you. This next question is in regards to duplexes or triplex suites, where the owner lives, say a duplex, the owner or one person owns both sides of the building, but they live in one and then they want to license out. They want to obtain a license for the second. Can they do that? Is it considered primary residence, secondary? How would you define it?
That would not be primary, because that's not, if they're different addresses, right? 101 A, B, and C, they'd be different. So that would be a non-primary resident location or ticket. right? So if the owner lives in A, that's their primary resident. B and C would be considered their non-primary residents. So they'd be required to have 3 licenses for that.
Okay,
Dwayne, if I can just add, in a condo situation, usually condominiums that are duplexes or triplexes are 2 or 3 different units. So to sort of add on to what Terry has said, in that situation, you would actually have not only different addresses, you'd have different titles.
okay. And this question is now specifically for Doug. Should a condo corporation decide that they want to institute a bylaw or a rule, can you offer some kind of guidance in regards to how they should define what a short-term rental is?
So if you're going to put it in a bylaw, then prior to, let's say, within the last year or so, the most common amendment to a bylaw or a declaration or a rule was to set a minimum term. So 60 days or something like that. The problem with that is that if you're trying to file that in land titles, residential tenancy has taken the view that that sort of thing, if it falls within the Residential Tenancies Act, setting a short term is contrary to the Condominium Act. So I would stay away from using short term and I would use language similar to what I had, something that makes it clear that it's not falling within the jurisdiction of the Residential Tenancies Act. So speaking about using it for commercial purpose, speaking of using it for providing accommodation on a transient basis, that sort of thing, or prohibiting use for accommodation on a transient basis or something like that. So, but I would urge all corporations, if you're going to do something like that, work with your property managers and work with your lawyers to make sure that the language, 1, is enforceable on its own right, and 2, if you're filing in land titles, it'll get through there.
Okay. Would there be another question, probably for the enforcement end of this? For existing short-term rentals within buildings, will there be a grace period for any rentals that have been booked before the February deadline?
Will there be,
I think it's the April deadline.
Or, yeah, possibly April, yeah.
So April 1st is when the bylaw comes into force. So the question will be, or to answer your question is, individual or short-term operators need to apply before April 1st to be able to operate a short-term rental accommodation. Is that kind of answering your question?
I think so. Yeah.
I don't know about the grandfather clause that you refer to. At the end of the day, we're saying if you're operating a short-term rental accommodation, come April 1st, you get a license, right?
Yeah, just for an abundance of clarity, if the question is if we're allowing anyone to who's renting prior to April 1st, the bylaw is not enforced, so we don't have a position with that. If they're operating, they're operating. But as of April 1, they need to be licensed to operate. That's why we've opened up the ability for people to start sending in their applications now. Terry has already begun hiring staff, so we're in the position that we could start to the process of licensing.
Okay. One of the other questions asked a couple of times, and it's in regards to the phone number or contact information that has to be on that decal or sticker. Does it have to be contact information that gets them directly in contact with the unit owner, or can it be a call service, or how does that work?
Well, the requirement in the bylaw says it needs to be monitored 24/7. So to answer your question about a call service, it's something that really hasn't crossed my mind. The thing is, the operator needs to be available to address any issues that are coming through that line 24/7. So whether initially it's a call service that takes the call and then forwards it to the operator immediately to address the issue, to me, that would be acceptable. If it's a call service to say, oh, thank you, leave me a message and we'll get back to you tomorrow or the next day, that's not acceptable.
Okay. And
And if I can give you just so that your audience has the exact language, the language of the bylaw says that the operator's name and license number are posted near the door on the exterior of the SRA together with a telephone number that is monitored by the operator or an agent of the operator 24 hours per day. This signage is not required to be posted when the operator is in residence. So if it's a primary residence and they're living there at the time, then they can take that sign off.
okay, so the signage is only for non-resident STRs.
No, it could apply to primary residents because they have that 150 days, right?
Oh,
That they can rent it without them being there.
okay. And is it to be assumed that an email address on that sticker would not be sufficient?
That's correct. It says with a telephone number.
Has to be a telephone number.
Correct.
Okay. Is there anything that the three of you wish to add while I'm kind of going through some of these questions?
One of the big questions that came up in the people that were submitting beforehand, Dwayne, was, and it's an easy one, so I'll answer it. What do I do if there's a party going on, a short-term rental at 2 a.m. In my building? Who do I call to get so I can get back to sleep? The answer is you call the police. You probably don't want to call your board of directors because there's not a lot, they're going to be just as effective as you are in getting it to stop. The folks at bylaw enforcement of the city of Winnipeg aren't there for emergency situations. They're for enforcement after the fact. And if there's noise going on and it's breaching a noise bylaw, then it's up to the police to get out there.
And in addition, Doug, just to add to the police, even the first step would be that operator phone number that's
Absolutely.
listed on the short-term rental. They need to be accountable for that noise going on. It's their responsibility to address the noise going on. So to me, that's the first step in the right direction. And if police need to be called, I would also share the number with the police in regards to who the operator is that's listed on that short-term rental.
Okay. Also in regards, a question that was asked, I think is a good question in regards to the records that need to be maintained by the owners of short-term rentals. Can you give us an example of what type of record has to be maintained?
I'm just flipping through the bylaw quickly. It talks about the number of nights the short-term rental was rented. So the operator must maintain a minimum of 3 years of the following records on an ongoing basis and provide them to the city upon request. Number of nights the short-term rental was rented. Rental type was an individual room or the entire dwelling. Names of customers who provided payment for each bookings. The nightly price and total price charged for the short-term rental accommodation.
Okay. Also, one of the questions brought up that Doug might be able to answer more effectively, or most effectively, is that some condo corporations have within their bylaws that there are to be no signs or posters or anything within common areas. So is the posting of these permits on the exterior of the door leading into a hallway, presumably, going to violate any of those bylaws?
That's a great question. And as I read that question, and as we were going through today, I was thinking to myself, gee, I hope Dwayne doesn't ask me that. I mean, you've got a problem, and the corporation has a problem because, and the unit owner certainly has a problem because on the one hand, they need to comply with the city bylaw, obviously, and it also needs to comply with the bylaws or the rules of the corporation. And when they conflict, then you have an issue. I would certainly get some advice on it because it may depend upon the language of your bylaw. But I would off the cuff say that, you know, if the city has a requirement, the city bylaw is going to trump the corporation's bylaws. So you've got to comply with the city bylaw and not the corporation one. And hopefully the board of that corporation will see it that way. And if I was a board and I had that no posting signs rule or in the bylaws, I would get proactive and I would put some parameters around what you can post in order to not trigger enforcement, or maybe even change that bylaw or rule to the extent that you can. But certainly, you know, a policy that, you know, we acknowledge that the city bylaws need to be complied with if you're doing a short-term rental, and you know, any signage needs to be either approved by the board or set, you know, can't be bigger than this and can't go and has to be put here. So you're more specific in the direction of where these signs can be and what they can look like.
And Dwayne, it's Winston. If I can, I don't want to ask Doug the question, but I'll just put out there's a comment that he might want to comment on. Is, I mean, our trigger number one is that we do require an approval letter from the condo board. So part of that should be hopefully a good understanding that the applicant can make them aware that if they do have that restriction, this is a requirement under our bylaw. And I will say that the requirement that we have put in place was based on some consultation that we did that recognize that there's a potential impact to the neighbors. So it's not it's not a negative thing necessarily to the other unit holders, because it does give them a contact number to be able to communicate if there's an issue with that unit and its operation. But I think the trigger point is that we require that approval letter. So put that out there.
Okay, so just to clarify that last question, it's the position that the notices have to be on the exterior of the door to comply with the bylaw, and that probably gives it some kind of an exemption if it's a condo bylaw rule violation.
Oh, Winston raises a good point. I mean, I'm thinking off the top of my head here, but if you have a bylaw that says you cannot post, you know, a sign in the common elements, it's the board could consider putting that in or not issuing or qualifying the approval letter by saying, although short-term rentals are not prohibited by our bylaws and rules, the placing of a sign in the common elements would be, and draw the city's attention that you know, somebody who has a short-term rental would not be able to comply with the city bylaw.
Actually, my comment was the opposite, to be candid with
Oh,
you.
really?
Is that, yes, is that our bylaw, we would enforce our bylaw, and that's a requirement in our bylaw. What I'm suggesting is that if there's a conflict within the condo bylaw, that the boards should recognize that that's a potential as they provide their approval. If they don't want that, then they should not approve. I should not say that. They should understand when they provide their approval that our expectation is that there is compliance with our bylaw across the board.
Okay. And one of the other questions that's come in a couple of different times, and it would be for people that only want to list their property as a short-term rental for short periods of time during the year, say for a 2-month period or something of that nature, not as an STR for a full 12 months a year. Can they get permits that are shorter, or is there just one permit for the whole year? How does that work?
Sorry, I forgot
It-
myself. There was some fire trucks passing by earlier, so I muted it. No, it's one license per year. So it's not based on time. It's not based on 2 months of operation, 3 months of operation. It's an annual license.
It has to be renewed every year.
That's correct.
And is that renewal period, is it a fixed date on the calendar, or is it just based upon a rotating year based upon when you got your license?
It's based on when you got your license.
Okay. So it'll be the property owner's responsibility to initiate that process every year. There won't be notices coming from the city like there is for your driver's license or something like that.
No, there'll be reminders stating that your license is about to expire. There'll probably be our normal process here is I believe it's a 45-day and a 15-day reminder to renew your license.
Okay. That's good to know. Are there any issues that you can think of that need further explanation?
I'm reading one that I'll just underscore. It's kind of covered in my presentation, but it was it reads, can the condo corporation begin to fine the owner for non-compliance with the city bylaws if and when that period basically if the SDR operator doesn't obtain a license or doesn't provide proof of the license or application to the condominium corporation? The answer to that is, again, it's a different regime, and the condominium corporation cannot fine, unless you've got it in your bylaws that you or your rules that unit owners have to comply with the city bylaws, or this particular bylaw. If it's not there, then you haven't breached a bylaw or the rule of the condominium corporation, and the condominium corporation cannot levy a fine because you breached the city bylaws. That's up to the city.
Okay. This question is in regards to police background checks. Do they have to be done every single year as the license gets renewed, or is one background check fine as long as the license doesn't expire anytime down the road?
One record review check.
Okay, so
Time of application, and if there's issues within that record review, the police would identify if there's issues and they cancel that record review.
okay, so just to clarify that, if someone is managing or owning a short-term rental and they get their license and that license never expires, they renew it continually, say for a 5-year period, that one police check at the beginning when they first issued will be good for that entire period of time?
And to qualify, record review is a little bit different, not to get into police's process, but if a record review is done and it's on the police's records and they cancel that record review, they would inform us that they canceled that record review.
Okay, and then that would require follow-up action by your office.
That's correct. If the record review is canceled, and once again, I'm thinking ahead, this has never really occurred, but my suspicion would be is that we would look at revoking or suspending a license based on that. We would probably suspend it based on a hearing, and then after the hearing, it would probably look at revoking or suspending it. Or cancel, sorry.
And another question, under the current or not proposed, the actual bylaw that will be in effect, can a condo corporation demand information about the occupants of a short-term rental if a license has been permitted, such as names, contact information, or anything of the people that are staying in the rental?
No, we have to follow privacy legislation and rules, and I don't believe we would be able to give that information.
Okay, so the person that rents out the unit, they obviously have to keep that information to themselves. They have to collect it, then keep it to themselves, and then submit it if necessary to your officers should a concern arise.
Correct.
Okay. Just going through some of the most recent questions. In regards to the police background checks, can you offer some clarification in regards to, like you did say that earlier, that if someone had a record for sex trafficking or human trafficking, that would be an adverse record and a license wouldn't be permitted. Can you give some examples of what other convictions might trigger refusal for a license?
Without our partners being here with the police service, I really couldn't get into detail in regards to what would be triggered. We did touch base on looking at specific conditions of noise complaints and stuff like that. But once again, the record review wouldn't capture some of that information. The information I'm talking about would be more disclosed information to us through the application process.
Okay. And do you know if that record would be simply information held by the police, or would it have to relate to criminal convictions?
Could you repeat the question?
In regards to the records that the police have, would it only pertain to criminal convictions, or could it pertain to just general information the police may have about a licensee or about a location?
No, it would be criminal convictions.
Okay. And also, one of the questions is, do they need to, do the short-term rental operators need to be licensed by April 1, or simply have the application in by April
1? So that's a tricky question. Definitely they need the applications in by April 1st. My hope would be is that we'll be able to get through all the applications and do all the inspections and do what we need to do by April 1st. However, if just as an example being, if there's a handful of them that aren't fully issued yet, but the application occurred, there would be a little bit of wiggle room for us to work with that applicant. If the situation occurs where a complaint comes in April 2nd for a short-term rental operator and there is no application or no communications, we would enforce it immediately.
I would just add that because we've received approval from council to begin receiving applications prior to a bylaw being enforced, that there would be less tolerance for someone sending in an application on April 1st, as we will be doing more media releases on this. There would be candidly not a lot of excuses not to get your application in early. So all those that come in on April 1st will likely be informed that they would have to cease operating because by the bylaw itself, black and white, you cannot operate without a license as of April 1st. Hence, we've received the authority to receive applications prior to that. If there's a delay on our part to get the license out and they provided it earlier, then obviously we will have some discretion to try to remediate that in a fashion that would not penalize a licensee or applicant in an adverse manner due to something on our end. But the submission of applications fully within their means to do so.
Okay. Another question that I think is probably a good question is, should damage occur to the common area of a condo corporation that's caused by someone who who is renting a short-term rental, how does the corporation go about dealing with obtaining remuneration? Is that going to be just through their bylaws and fines, or is there some avenue of remuneration through the bylaws, through the city bylaws?
So I'll let Terry and Winston mull that over. But I will say that if a tenant, be it long-term or short-term, causes damage to the common elements and does not make good on that damage, then the unit owner is responsible for the actions of that tenant. So if you had a short-term rental and they did something with common elements and you couldn't find and nobody fessed up, then you can certainly pursue the unit owner, and there are your bylaws and your declaration will have a lot about how the corporation can do that. It could even be including putting a condominium lien on it in some instances if it's not done right. But as for the city bylaw, I'll let Terry and Winston answer.
Yeah, thanks, Doug. Yeah, so specific, our bylaw does not place obligation on the renter. It's on the licensee who holds the license, so they would be the one responsible for dealing with it. But our bylaw doesn't speak to specific common areas or anything like that.
Okay. And should a dispute arise between a unit owner who's renting out under the with a license and their condo corporation board of directors in regards to something, say, like damage to property and whatnot, and it can't be resolved, can the condo corporation then contact your office, being the city, and saying, we're having difficulty with this, we are no longer of the view that this person should hold that license? Can it be revoked based upon that type of a situation?
That's a tough question. I'll maybe have a stab at it and then maybe let Winston have a gander at it. But my thought would be no, it's between the condo corp and the renter. Would we listen to information if the condo makes the decision that they're not allowing that rental unit to be a short-term rental operator anymore? That most definitely we would want to receive that information. But as mentioned earlier, I think it was Winston that mentioned it earlier, that this individual already purchased a license for a year. So if the condo corp decides that the operation of that short-term rental isn't allowed anymore, we would probably look at it at renewal. However, with that being said, if there's issues within so if the condo corp is having issues within A, B, and C, and it's in violation of our bylaw, and a complaint came to us and we're dealing with the same issue time and time again, yes, we could look at inputting or implementing a condition and on a license, and or look at suspending or canceling a license should it be in contravention of our bylaw. So I don't know if that really totally answers your question. I don't know, Winston, if there's anything you'd like to kind of add on to that.
Yeah, it was a great question, Dwayne, and
Yes.
good answer, Terry. What I would suggest is this: for the most part, I mean, we're still fleshing out processes because there's going to be a number of different nuances involved. So I'll give you our considerations. Number one, we would likely do so from the perspective that it's upon renewal. If that approval is being rescinded, then upon renewal we would not reissue that license. We also are balancing between so that decisions aren't so what's the right term for it, but arbitrary, right? So on a board that we want to issue it, now we don't, and so forth. So that's why we're looking at it upon renewal. However, if the contravention is so egregious, we will look at it from the perspective of does it contravene our bylaw? And certainly upon investigation, if the evidence is there to support the claims by the condo board that has caused them to reconsider their decision, and we're able to determine that yes, it's a breach of the City of Winnipeg bylaw, not the condo bylaw, but the City of Winnipeg bylaw, that enables Terry as the one overseeing this program then utilize the tools at his disposal, whether that is a suspension license, addition of conditions on the license, issuance of fines or penalties like tickets and so forth. He can implement all those different things, or in fact, if it is so egregious, he can look at canceling the license. There's a due process related to that. So the licensee can appeal Terry's decision to our standing policy committee, and then once that decision is made, the decision is final. So hopefully that answers the question of your audience, but it does consider, our process considers all those wide variety of nuances that can play into a decision.
And Dwayne, I would just add, underscore that condominium boards should be very careful, that they don't make decisions on an arbitrary basis. That if before they start to try to withdraw an approval, for lack of a better term, that they have the authority within the declaration, bylaws, and rules to withhold permission in the first place. So if short-term rentals are permitted and there's no qualifications around that, then just deciding you don't like it because somebody isn't complying with the rest of the bylaws and rules, withdrawing it, that is something that should be considered before you do it. You may have other remedies. If somebody's causing damage, you may have other remedies to go after the unit owner in order to recover the damages. Or if they're in breach of the noise duties, or duties not to interfere with everybody else's use of their units, that you may have remedies for that. But make sure that the decision is not arbitrary and you've got something to base it on.
So based upon your response, Doug, I guess it is incumbent upon directors or condo boards and their property managers to ensure that they keep proper records about any concerns that arise from a short-term rental.
Yes, absolutely. And remember, in condominiums, and this applies to short-term rentals and everything, the power of the board and of the corporation comes from the act, the declaration, the bylaws, and the rules. If it's not within those documents, you may not have authority to do it.
Okay. Another question that was asked is, will there be a physical inspection if someone applies for a short-term rental? Are the enforcement officers within the city of Winnipeg going to be doing actual inspections of the locations, physical inspections?
Physical inspections, yes, at time of application and annually.
So they can expect to be visited or requested access to the property every year then?
That's correct.
Okay. And if access isn't granted or isn't easily obtained by the investigators, what happens then?
Well, on application, you don't receive your license. On renewal, we don't renew.
Okay. And should there be any shortcomings, or should there be any areas that an investigator says this needs to be fixed, changed, repaired, whatever the case may be, I would assume, is there going to be follow-up on that? Compliance dates, times, things of that nature?
Yeah, good question. So what would happen is if we inspect a short-term rental accommodation and they're in violation of the community safety business license bylaw, so specific to short-term rental accommodations, an order would be issued to them. The order would outline what the contravention is within that occurred during the inspection, with the compliance date identified. And at that term, a reinspection would occur. And if it's not rectified at that time, it would be the next step to ultimately, once again, your license could be suspended and or revoked.
Okay, thank you. I think I've pretty well reached the end of the questions. A lot of them have already been answered, or they don't apply. Is there anything that, in summation, that the three of you would like to add? And then going forward, no doubt there's going to be questions that people are going to have They're going to think about later tonight or tomorrow or in the following weeks who they can contact, how they should go about addressing those questions and concerns?
Yeah, sure. Doug, if you're okay, maybe I could go first and I could turn the floor over to Winston in case there's anything to add. So to answer your first question, yeah, if there's any questions, we're referring people to the website. There's a lot of really good information there in regards to the requirements. There's a link to the direct bylaw. There's a very good information within the website. Also included within the website, if there is more specific questions or scenarios, because we do appreciate that every scenario could be unique and challenging, that requires a discussion. I had mentioned earlier the CMS licensing at winnipeg.ca, I believe it is the email address that's on the website. So that's available for individuals and customers to be able to contact for a response. In addition to closing, I just want to mention, and thank you folks for inviting us today. This is a new bylaw. As you could appreciate, it's a very complex bylaw and situation and short-term rentals in itself. So, it's a very good starting point for us to start working on implementing and enforcing the bylaw. And we're always open and always looking at making improvements to the bylaw down the way. I think our next report back for potential changes is in the 2 or 3 year mark. So we're definitely going to be monitoring the whole bylaws itself, the administration to the bylaw, the enforcement to the bylaw, and we're always going to keep our eye open and ears open in regards to making the bylaw better, and to be able to address any issues that aren't being resolved within the existing bylaw, and or to come up with ideas for amendments to the bylaw down the road to make it better, more enforceable, and more conducive to everybody involved. So once again, just wanted to thank you for your time. Winston, would you like to add anything in addition?
Yeah, thanks, Terry. And first and foremost, thanks to the CCI and yourself, Dwayne, for inviting us. We really do appreciate the opportunity to relay information, and that's the approach that we're trying to take. Number one, first and foremost, is putting a new regulatory environment for SCRAs in place. But hopefully that's not bad news to some of the people out there, because candidly, we want the industry to be successful. We've been told by our political leaders they want it regulated, so we put that in place. Our goal is certainly for the industry to be successful, and that means both the operators as well as the neighborhoods or communities or within condominium units, that they are operating in a manner that everyone's happy. That's our most ideal state. Certainly, we're there to ensure that the regulations are complied with. But for the most part, through our process for the last couple of years, we found that a great majority of owners and licensees or future licensees are very good, very compliant. Certainly, I think they add value to our city. Our goal is for them to be successful in a manner that's going to be, aligns well with the community in which they operate within. So we are introducing something new, but it is a matter of what we want to communicate both with people who have concerns, but also licensees, so they are successful.
Great, thanks, Winston. And you've got maybe 1 minute, Doug.
Okay. Well, as long as I don't have to touch any slides, I'll be good. And again, apologies for that, but I'd like to thank you, everybody, for listening, for the kind attention. I want to thank Terry and Winston. Great presentation, great working with you guys, and a lot of useful information. I was taking notes through the thing as well. We've folks who've got a brave new world here in the condominium industry and in Winnipeg with respect to the city bylaw. Now that condominiums can look at doing something within their own governing documents. So the next months that follow will be interesting to see how this all shakes out and what processes develop and all that. You asked Dwayne whether or not people want to reach out if I would answer questions, I'd be happy to. And so feel free to do that. And everybody have a great afternoon. Thank you.
Okay, on behalf of the CCI Manitoba chapter, I'd like to thank Doug Forbes, Terry Cormier, and Winston Yee. You guys have been outstanding. You've answered all the questions. I'm sure that there's no confusion about this at all anymore. And if you have further questions, as Terry and Doug both indicated, their offices are open. You can contact them, and hopefully they can either direct you to the answers or they can provide them. And I'd like to thank everybody for attending today. It's been a great webinar. Have a good
Thanks for
day.
hosting,
Thank you.
Dwayne.
Thank you.
Okay, have a great day.
You too.